Hello everyone, it's Harry Sherrard here and welcome to video number 8 of my Employment Law Foundation course, which is about GDPR, which of course stands for the Great Data Protection Racket. Or at least that's what I think it does, judging by some of the dodgy advice that's circulating out there from some so-called experts. So we'll then look at another acronym, a DSAR, Data Subject Access Request. So let's do that by way of a case study. So the case study is coming up on your screens now. George is a poorly performing employee who has been on management radar for a few years, and there have been various emails about him exchanged between managers and HR. Many of the emails are uncomplimentary about George, but have been headed private and confidential. Now there is a restructure taking place, and we've had a first consultation meeting with George. He sends us a data subject access request under GDPR. Can we avoid sending George the uncomplimentary emails? Now, I guess it's not any great brain teaser, this case study, because most of you will know the answer to that question, and the answer is no, you can't avoid sending those uncomplimentary emails. The fact that they're headed private and confidential, that doesn't mean anything. GDPR will always trump confidentiality. In some ways, count yourself lucky that they are only uncomplimentary and they're not outright damaging, because that does happen with increasing frequency. So the purpose of bringing this case study into the course is to demonstrate at this point that careless email communications between managers, or indeed between managers and HR, can have consequences. And always bear in mind that further down the line, your emails might be read out in a tribunal in the worst case scenario, and that could be a pretty uncomfortable experience. There's a very high awareness, I would say, these days of subject access requests, and it has now become pretty much, I would say, a standard part of the process. If an employee sees a dispute brewing with the employer, then almost the first thing they do is to bring a subject access request and obtain therefore all the information that the employer, the data that the employer holds on them. It can be very onerous for an employee who's been with you for many years, but again, that's just the way it is. Nothing we can do about that. GDPR gives employees that right. But as we said in the case study, provided the information is professional and has been managed properly, you shouldn't have too much to worry about that. But definitely a good idea to train managers to be discreet and professional about what they put into their emails about their members of staff. So that concludes video number 8. I look forward to speaking with you again soon. Thank you.